We'll hear argument this morning in 2434 in re Facebook, a petition for writ of mandamus from Harris County and the 14th Court of Appeals District. Justice Busby and Justice Huddle do not expect to participate in the decision of the case.
May it please the court, Ms. Ho will present argument for the relators. Mr. Keller will present argument for the amicus. Relators have reserved 5 minutes for rebuttal. Ms. Ho will open with the first 10 minutes and will present the rebuttal.
Mr. Chief Justice, and may it please the court. When legislatures immunize certain defendants from liability, whether it's MedMal, tort reform, or Section 230, the job of courts is to enforce the immunity. Policy-laden concerns about the nature and scope of the immunity are for legislatures, not courts. The plain text of Section 230, decades of uniform precedent, and Congress's most recent amendments all confirm that Section 230 bars plaintiffs' claims for three fundamental reasons. First, the plain text. Section 230 bars suits that treat a provider as a publisher of another's speech. And plaintiffs' claims here do just that, because the sole basis of liability is publishing that third-party speech in the first place. Second, artful pleading. Plaintiffs can't end-run Section 230's plain text by reframing their allegations or claims in terms of Facebook's own conduct, rather than the third-party content that is the sole basis for liability. Third, the 2018 FOSTA amendments. Congress left untouched Section 230's immunity granting provisions, thereby, under this court's precedent and the US Supreme Court's precedent, adopting the uniform interpretation of dozens of courts over the last 2 decades.
Ms. Ho, could I please ask you, how is the claim of failure to warn, how does that fall under Section 230C1? No provider or user of a computer service shall be treated as the publisher or speaker of any information. The claim isn't anything having to do with defamation or speech. It has to do with failure to warn.
Yes, Your Honor, and a failure to warn is no different than a claim that the third-party content shouldn't have been published in the first place. After all, a warning is an instruction to disregard or not to read or not to attend to the third-party content, no different than a decision not to or to publish that content in the first place. And that's the teaching of the Fifth Circuit in my space, of the Wisconsin Supreme Court, the most recent state high court to address this issue. Plainly held that with respect to failure to warn claims in particular in that case. And Your Honor, I think this is where the rule against artful pleading really comes into play, because the statutory language says you cannot treat a provider as a publisher, and you cannot avoid that plain text by reframing your allegations in terms of a failure to warn or a failure to protect to try to get around that plain text.
Except that the claim is not about the published statement. The claim is about the failure for the company to warn that this could lead to violent sexual behavior.
And as your question highlights, Justice Lerman, without the third-party content here, there would be nothing to warn about. There would also be no connection between the egregiously harmful consequences that flow to the plaintiffs from that third-party speech and Facebook. Facebook's only connection to the content, to the conduct, and to the consequences is publishing the third-party speech in the first place, and that's precisely what Section 230 bars, is treating a provider like Facebook as a publisher of third party content. And I think
Ms.
if you
Counsel, is there a, sorry, go ahead, Justice Guzman.
No, go ahead, Justice Blackwell.
Thank you. Is there a distinction perhaps between claims that seek to hold Facebook liable for, not policing the content sufficiently or not warning of it, and claims like the statutory claim here that are premised on Facebook's alleged knowing and intentional involvement in a human trafficking scheme? I mean, in one bucket, you have you're liable because of someone else did and you should have stopped them. And in the other bucket, you have you did something that's probably criminal and should be liable for it. But why wouldn't we look at those two differently in the context of Section 230?
Two points to that, Your Honor, and I'll take the last part of your question first. I think highlighting that plaintiffs' claims do try to reframe their allegations in terms of Facebook's own conduct is exactly the type of artful pleading that the Fifth Circuit in MySpace, the Wisconsin Supreme Court in Daniels, and countless of other courts have said you can't evade the plain text by engaging in artful pleading. But let me take your first part of your question. And the answer depends on the allegations. And of course, all of these cases are going to turn on the allegations, especially on in a Rule 91A case like we're here on today. And the allegations in this case with respect to the Chapter 98 claims are no different than the failure to warn and failure to protect claims that plaintiffs bring with respect to negligence. In other words, Facebook is alleged to have violated Chapter 98 by saving money, by not giving warnings, by not engaging in public service campaigns. So in this particular case, there is no difference between the allegations that plaintiffs rely upon in their Chapter 98 claim and the allegations that they rely on in their negligence, failure, negligence and gross negligence and negligence undertaking claims. And in our view, that underscores that all of the allegations here, if this suit is allowed to proceed, would treat Facebook as a publisher exactly what Section 230 prohibits. And I think that the 2018 amendments in FOSTA confirm that, because Congress left the immunity granting provisions there untouched. And again, under this court's precedent, it's presumed to have adopted the uniform interpretations of decades of courts. I want to be very clear, and I think this is a crucial point. Congress most assuredly, when it addressed the evil scourge of sex trafficking in FOSTA, did not leave the victims of these heinous crimes without a remedy. It gave victims and law enforcement, state law enforcement, important new tools, while at the same time avoiding a 50-state patchwork of divergent liability regimes. Congress.
Go ahead, Justice Blackwell.
No, please go ahead.
The CDA imposes criminal liability against a distributor for knowingly displaying obscene material. And I think there's an argument that the allegations in this case are directed toward Facebook as a distributor rather than as a publisher. And can you speak to the distinction between publishing and distributing in this context and your position with respect to that?
Certainly, Your Honor. Thank you for the opportunity to address that. I do think it is telling that my dear friends on the other side advance an argument, advance an interpretation with respect to this that no court has ever accepted. And the reason for that is simple. If you look back to common law, the reason that distributors could be held liable as publishers when they had knowledge was because the plus factor of knowledge made them the legal and the functional equivalent of a publisher. And so they were held liable as publishers, which is exactly what Section 230 prohibits. So I think Section 230 is perfectly consistent with the common law, and it's not consistent with the common law. It's basically overriding the common law, which held distributors liable as publishers when they had knowledge. And of course, holding a provider liable as a publisher is precisely what the plain text of 230 precludes.
It just seems like the immunity argued for here is a far cry from the Good Samaritan, that's the words the statute uses, provision, which is to say, if you do something, we're not going to blame you if it wasn't enough.
I see my time has run out. Mr. Chief Justice, may I respond?
Please, yes.
Thank you so much. Your Honor, I think the last part of your question really captured the heart of this case and why it really is within the mainstream of Section 230. And I think what Your Honor said was, not holding providers liable when all of their efforts, despite all of their best efforts, as Facebook takes here, to block, to remove, to eradicate this egregious content from its platforms. Holding Facebook liable for not doing enough is precisely, I think, the concern. That was a concern that Congress had when it wanted to ensure that providers were encouraged, were incentivized to take these sort of steps without subjecting them to a patchwork of 50 state liabilities when those efforts prove tragically imperfect.
Any other questions? Thank you, Ms. Ho. Mr. Keller, we'll hear from you.
Thank you, Mr. Chief Justice, and may it please the court. I'd like to highlight three key points. First, I'll briefly address plaintiffs' artfully pleaded claims. Second, I'd like to address distributor liability along the lines of Justice Bland's questions. And finally, I'd like to explain how allowing state civil litigation like this would radically transform the internet through a 50-state patchwork of laws. So to start with, plaintiffs' claims are artfully pleaded attempts to hold Facebook responsible for third-party online speech. To be very clear, all Facebook did here was publish third-party speech. The only thing that plaintiffs allege that remotely connects Facebook to this heinous sex trafficking is that third-party online speech. Now, from that, the plaintiffs assert liability for failing to take down or to warn about third-party speech. Those are inextricably intertwined with the third-party speech. They're all attempts to hold Facebook legally responsible, which is why they're barred by Section 230.
Mr. Keller, is there the fact that Facebook allegedly profits, and not insignificantly, from targeted ads to minors and that sort of thing, does that provide a connection at all?
The immunity under Section 230 is if you are treating an entity as the publisher or speaker. In other words, you're trying to hold them responsible for that third-party speech. That's what the immunity covers. The immunity would not cover other forms of actual conduct by an actor. For instance, if a website was going in and editing content to avoid legal regulators, then that entity would be becoming a content provider and the immunity wouldn't cover that. But here the allegations are all that this third-party speech is the only thing that ties Facebook, again, to this heinous sex trafficking. That's barred, and the victims do have other rights. The federal civil remedy that was exempted under FOSTA, and indeed state claims against the traffickers themselves. If I could turn to the distributor liability point, along Justice Bland's questions. Under the common law, a distributor with knowledge was treated just like the original publisher, which is why courts also called them at different times secondary publishers, republishers, or conduits. But in Section 230, Congress said you cannot treat service providers as the publishers. So Justice Thomas, in his malware bite statement, is absolutely correct that the common law imposed liability when distributors of unlawful speech had knowledge that that speech was unlawful. But the line of cases that Stratton Oakmont cited, that's the case that Congress was enacting Section 230 against to address that, that reached that result through a premise that's crucial here. And that premise is that a distributor with knowledge was treated just like the original publisher. At base, the common law was asking, who is legally responsible for mere speech? Can you be legally responsible for someone else's speech? And Congress answered that in Section 230. I'd also like to note the textual distinction that Section 230 makes is between service providers and content providers. Service providers like Facebook have immunity. Content providers, like the traffickers here, are legally responsible for their own speech. That's precisely what courts across the country, including the Fifth Circuit, have held time and again. And Congress's 2018 amendments directly align with that quarter century of precedent, as there are no exemptions for state civil claims under the Section 230 regime.
Counsel, I'm still having trouble understanding why there isn't a difference between holding Facebook liable for the speech of third parties and holding Facebook liable for its own knowing involvement in a human trafficking venture, which is what the statutory claim alleges.
Justice Blackledge, I believe there's a difference between what the plaintiffs have pleaded here and just coming into court and pleading threadbare recitals of elements, as opposed to what the reasonable allegations and inferences are under Rule 91A. There's a big difference between that. If there were, for instance, a hypothetical, and this is not this case at all, but if a trafficker had an agreement with a website and that they were going to give a kickback of some sort, that would be a very different case. But the plaintiffs haven't pleaded anything like that. And in my final time, if I could turn to the plaintiffs' theories would radically transform the internet. They would create a 50 state patchwork of laws. It would stifle startups and innovation, and it would effectively impose a notice and takedown regime for the entire internet. That's not what Congress created in Section 230. Plaintiffs' arguments should be addressed to Congress, not state civil courts, and Congress is the proper forum to address these sweeping policy decisions.
Any other questions? Thank you, Mr. Keller.
Thank you.
We'll hear from the real parties.
May it please the court, Mr. Harris will present argument for the real parties in interest. Mr. Stone will present argument for the amicus. Mr. Harris will open with the first 15 minutes.
Mr. Chief Justice, and may it please the court. Our brief thoroughly addresses the cases cited and arguments made by Facebook, and of course, I'm happy to answer any questions about them. But since the briefing was completed, Justice Thomas has issued an important statement that analyzes the state of Section 230 jurisprudence, and I would like to focus my time today on this recent development. While courts have generally favored a broad reading of Section 230, Justice Thomas has criticized the sweeping immunity approach for using non-textual arguments and policy and purpose to read extra immunity into Section 230 where it doesn't belong. The court should follow Justice Thomas's text-based approach and dispel the judicial overreach that he has condemned. With this framework, there are 2 points I'd like to emphasize. First, plaintiffs seek to hold Facebook liable for its own conduct in suggesting friends and encouraging social connections between and among its users, not passively publishing third-party content. And second, mining a user's personal data and applying proprietary algorithms to recommend friends and encourage social connections with other users is not publisher or speaker activity within Section 230's protections. On its face, Section 230 only protects Facebook from claims that would treat it as a publisher or speaker of information provided by a third party. Nothing in Section 230's actual text confers a broad immunity for all claims where the facts in any way involve a third party's communication. As Justice Thomas explained in his statement, there are several reasons to doubt whether the sweeping interpretation of Section 230 adopted in many cases and advanced by Facebook here is correct. First, Section 230C1 only protects against publisher or speaker liability. But the first appellate court that addressed Section 230, the Fourth Circuit in Zeran, extended its reach far beyond entities being treated as publishers and included entities that were merely distributing content. Subsequent courts, citing Zeran, took this sweeping interpretation and adopted it as a categorical rule across all contexts. But if Congress had intended for Section 230 to have such an all-encompassing effect, it could have simply created a categorical immunity in Section 230C1 by saying, no provider shall be held liable for information provided by a third party. After all, that's the language that Congress used in the very next section, Section 230C2, which governs the removal of content.
Mr. Harris, in discussing the provider's conduct, I guess the Second Circuit talked about the conduct being inextricably linked to the provider's alleged failure to edit, monitor, or remove offensive conduct. And it does seem to me that there's a link, whether it's inextricably or not, I'll let you address, but
This goes to Facebook's argument of but-for causation, and but-for causation isn't the test. The Ninth Circuit addressed that in Doe versus Internet Brands, and the court there explained that publishing activity is a but-for cause of just about everything that a website like this is involved in, and that Section 230 doesn't provide a general immunity against all claims that are derived from third-party content. So that simply goes to the but-for cause. The allegations that plaintiffs are making here are not inextricably intertwined. They're actually very, very separate conduct. You start with the connections that Facebook is making. Facebook buys data, monitors, and has a proprietary algorithm that allows it to make connections. And that's what Facebook is in the business of. I mean, Facebook's allegation, or the plaintiff's allegations here, are that Facebook's own conduct did things like have a company mission to connect people in order to create profit. And Facebook used its proprietary algorithms to generate targeted recommendations to each user. Facebook is the first point of contact between sex traffickers and the children who become their victims.
Mr. Harris?
Yes.
Facebook uses transmitting as a definition of publishing. So they say publishing and transmitting are roughly equivalent. Do you agree with that? And if transmitting information is, if there's immunity associated with transmitting, do these allegations in this case stand?
Well, the most important thing there is that the information that's for which preemption is allowed under 230C1 has to be information provided by another information content provider. So it can't be anything that Facebook is doing. And if Facebook is merely communicating information from a third party, that would fall within 230C1, but those are not the allegations being made here. The allegations being made here is that Facebook is in the business of making connections. That's what Facebook does. That's what its website is designed to do. And it makes connections between minors and adults who turn out to be traffickers. And that's Facebook's business.
But just going back to the text and leaving aside the effects, does the distinction between publishing and distributing matter? Is Facebook a publisher or a distributor? And, when Westlaw compiles court's opinions and puts them online, are they a publisher or a distributor? And is it different than when they put them in compile them in a book and publish a book of court opinions?
For information provided by the third-party information content provider, Facebook would be a distributor. Facebook would not be a publisher. To have liability as a distributor, the party has to either know or should have known of the illegal, or it's usually defamatory content is the way that arises. So it's normally looking at distributor liability. Because of the Stratton-Oakmont versus Prodigy case, Congress enacted 230C1 so that a distributor of content would not be treated as a publisher of content. And in the Stratton-Oakmont versus Prodigy case, the reason the court held that Prodigy there was to be treated as a publisher is because it had taken efforts to monitor comments and content that was put on bulletin boards, and it advertised itself as monitoring the content. And the court in Stratton-Oakmont held that made Prodigy a publisher. And that was what Congress was intending to overrule in passing 230C1. So you really have to go back to those roots to look at publisher and distributor liability. And that's where Zeran kind of started all of the courts down the wrong path, because Zeran came in, and although there's no indication in 230C1 that Congress was trying to eliminate distributor liability, Zeran came in and said, well, let's look at the policy. We're going to look at the policy of the Communications Decency Act, and we don't think Congress would have allowed distributor liability to stand, and came in and wrote very broadly.
How does your failure to warn claim fit into your analysis about merely making connections?
That is the other part of the claim. It's the making connections and then the failure to warn, Your Honor. Failure to warn is not covered under Section 230C1 because it doesn't require any monitoring of content. It doesn't require any changing of content. It is separate from the information being communicated. So Facebook here first made these connections between the traffickers and the victims, and then Facebook did not warn of the dangers that it knew of on the internet. It knew.
Where does the duty come from? A failure to warn duty, where does it come from? Well, here's where I'm going. Does Facebook have a duty to warn about this kind of illegal or dangerous communication on MySpace?
I'm not following with the MySpace connection.
Facebook has no duty to warn its users about bad communications that may show up on Twitter or Instagram or MySpace or TikTok or any of these other. It only has a duty to warn of bad communications that show up on Facebook.
It has a duty to warn whenever it knows that traffickers are using its website to groom children and to put them into human trafficking. And that's the
that duty can only arise regarding, I mean, by definition, it's a failure to warn of the dangers of the posts that are showing up on Facebook.
It's a failure to warn of the conduct being taken by traffickers. And yes, Your Honor, it's through those posts, but it's not treating Facebook as a publisher. It's not saying Facebook should have monitored those posts and done something different. What it's saying is Facebook knew that traffickers were on its platform and should have warned of those dangers. That's what the warning is. That doesn't have anything to do with the communication itself, and therefore doesn't treat Facebook as a publisher.
Except that no duty would ever arise if Facebook never published any of the dangerous communications. That's why Facebook has no duty to warn about dangerous communications on TikTok. But you're saying it does have a duty to warn about dangerous communications on Facebook, which inherently means it has to be, the duty only arises when it publishes those statements.
Your Honor, it does have a duty to warn on its own platform. And it's not that the duty doesn't arise until the trafficker reaches out. Traffickers are on Facebook grooming children. Facebook knows that. That is what triggers the duty. The communication may be part of the causal link, but the duty arises because of the conduct that the traffickers are engaged in on Facebook that Facebook knows of.
I take Justice Thomas's point, of course, that it's been widely discussed for some time, and Congress has amended the act to address some of these issues. So what is your response to the legislative acquiescence argument?
Your Honor, Congress in FOSTA did make some changes, notably to create some additional exceptions for enforcement, mainly against Backpage because of human trafficking. There was no amendment made to Section 230C1, and I don't believe Congress should be held to have adopted the case law. I mean, there are numerous interpretations, most of which give this broad immunity. There are some other cases in the Ninth Circuit and elsewhere that have a different reading. But Justice Thomas goes back to the text of the statute, and that's what this court should do, is look at the text of the statute. And I believe this court should make an independent determination of what the text says. And just because other courts have improperly interpreted it, this court should use its own judgment in determining the text of section 230C1. Again, plaintiff's claims here are based on Facebook's conduct in actively promoting contacts between the sex traffickers and victims, and that's not the content that Facebook passively transmitted with the platform.
Mr. Harris, does
yes.
it actively promote them by publishing them though, or?
It actively promotes through the contacts that it's making, Your Honor, and it's making the connections. That is the activity that Facebook is doing. This is not a situation like an email provider or just a bulletin board that has passive content that's being transmitted. This is a situation where Facebook is actively making connections. That's what it does. It makes contacts, it makes connections, that gets the use of Facebook up, that drives its marketing dollars and its advertising dollars. I mean, that's what Facebook's business is to make connections. And it does that to every single user. The problem is some of these users are sex traffickers and children, and it's making those connections. And that is the harm that is being created here, and that does not fall within section 230C1.
Mr. Harris, Ms. Ho, and Mr. Keller both mentioned the 50-state patchwork. If every state goes in a different direction on state civil liability, what is your most succinct response to that argument?
The 50-state patchwork, whenever that was discussed in section 230C1, was really to not allow different states to have different monitoring requirements, so that some states will allow these words, other states won't allow those words. I don't believe there is any evidence or indication that the internet will crash if section 230C1 is interpreted as written. Congress was very specific in the carve out that it made for preemption under section 230C1. As Justice Thomas pointed out in his statements, courts have read that too broadly. And if it is properly interpreted as applied, the carve out that Congress made for publisher liability, that will not wreak havoc on the internet, and Facebook will still be able to do business. As Justice Thomas recently commented, paring back the sweeping immunity that courts have read into section 230 would not necessarily render defendants liable for online misconduct. It would simply give plaintiffs a chance to raise their claims in the first place. This court should deny the petition for writ of mandamus.
Any other questions? Thank you, Mr. Harris. General Stone, we'll hear from you.
Mr. Chief Justice, and may it please the court. Facebook relies on two parts of section 230 to claim immunity here. Neither applies. Subsection C1 prohibits a plaintiff from attributing the speech of a third party to Facebook as though it were its publisher or speaker. Subsection C2 protects Facebook when it restricts materials in good faith. Plaintiffs' claims involve neither. Plaintiffs neither attribute the words their rapist said to the Facebook, nor claim Facebook wrongfully removed anything from its platform. Instead, plaintiffs seek to hold Facebook liable for what it did and didn't do, namely, knowingly profiting from and failing to warn about online child sex trafficking. These claims don't fall within either subsection C1 or C2, and this court should reject Facebook's artful redrafting of section 230 and deny its mandamus petition.
Counsel,
now,
what's your interpretation? What's your interpretation of the concept of treating Facebook as a publisher? What does it mean to treat them as a publisher?
Well, as my friend on the other side, Mr. Keller, pointed out, originally section 230 came to overturn a New York State decision that imposed defamation law, that imposed defamation liability on Prodigy. To treat someone as a publisher in this context is to treat them as though they were the original speaker of materials for purposes of a defamation claim, either in slander or libel. There are other contexts where this could matter, for example, copyright infringement or obscenity. But the core is that the person who's being treated as the speaker is being, for purposes of an element of a state or federal law claim, the words that are actually made are being attributed to them as though they spoke them, and not as though they merely distributed them, as Justice Bland has raised the distinction in several of her questions.
Wouldn't that kind of liability perhaps already be addressed by the prohibition on treating them as a speaker? It seems like the way you're looking at it, treating them as a publisher, prohibiting them being treated as a publisher doesn't really add anything to prohibiting them being treated as a speaker, the way you're looking at it.
Well, a couple of points, Your Honor. Publisher and speaker also map onto the common law bifurcation of the defamatory torts, where publishers were for libel and speakers are for defamation. But to sort of also go to this distinction in liability, recall that typically this court interprets when a legislature or when Congress uses one term of art and omits another, it meant to include one, not the other. I've heard from my friends on the other side a few times that their interpretation of C1 by providing publisher, by prohibiting the attribution of liability through publisher status, that it also meant to include distributor status. Both of those involve the transmission of information by a third party, but of course, the two are not the same. And by omitting that distributor piece, Congress didn't intend for C1 to extend immunity to situations where Facebook effectively just acts as a transmitter. I'd like to also move back to a question that you asked Chief Justice Hecht a moment ago regarding the effect of FOSTA on C1 and C2. The position of the state is quite simply that FOSTA doesn't apply or does not change the underlying scope of C1 or C2 here. It says nothing about state civil liability, state civil claims. Now, my friends on the other side,
Mr. Snow, what about it says that nothing precludes the state from enforcing a law consistent with the section, but it says no liability may be imposed under state law for anything inconsistent with the federal law. And so would imposition of civil liability be inconsistent with the framework that FOSTA sets out and preserves some civil liability, but federal civil liability?
Of course, Justice Bland. Subsection E3 prevents inconsistent state laws. To find out whether or not something is inconsistent, we have to look back to the substantive guarantees in C1 and C2 as fairly understood by the natural text. C1 prohibits the attribution of speech and C2 protects against removal. Now, my friends try to imply that everything else is prohibited because FOSTA had several other additional things carved out in E5. Of course, there's a couple of reasons this is incorrect. First of all, this court typically applies the canon of sort of reapplication or ratification by a legislature, by a subsequent law, when two things occur. One, the legislature readopts or otherwise sort of ratifies the position, and two, it's been given a conclusive interpretation by a court of last resort. As my friends on the other side cite from Scalia and Garner, they remind us that the mere failure of a legislature to correct extant lower court or intermediate court interpretations is not a sound basis for assuming legislatures adopted them. So this court oughtn't to assume just because FOSTA had several carves out it added to Section 230 that Congress was somehow imposing the broad immunity that Facebook is seeking.
Any other questions? Thank you, General. Ms. Ho, I believe you have 5 minutes.
Thank you, Your Honors. I want to begin by highlighting what I did not hear from my friends on the other side. I did not hear any meaningful response to the principle this court, the Supreme Court, Justice Scalia and Brian Garner have all embraced, which is the principle that where, as Congress did in 2018, when it amended Section 230, but it left the immunity granting provisions untouched, that courts deem Congress to have adopted the uniform interpretation. I think uniform might be a bit of an understatement in this context, the uniform interpretation of this language to bar claims like plaintiffs. I did not hear the name of any case or any court that has adopted my friend's reading of the statute to allow claims like those here. And I didn't hear any meaningful response about concerns about forum shopping and about this court splitting from the interpretation of the Fifth Circuit, every other US Court of Appeals and state high court to have adopted the issue. I did hear something that surprised me a bit when my friend, Mr. Harris, talked about algorithms and making connections. This case does not involve allegations like that. I'd like to point your honors to MR 877, where the plaintiff's allegations make very clear Facebook did not make this connection the trafficker did. It doesn't matter, but I did want to, for purposes of the doctrine and of the result, but I did want to make that clear. And Justice Bland, I wanted to address your question about publication and transmission. And I think it's worth reading in its entirety, the section. My friends on the other side rely extraordinarily heavily on Justice Thomas's statement respecting the denial of certiorari and malware bytes. But the part that they don't quote is actually the point that your question highlighted. He explains that Section 230C1's plain language, quote, ensures that a company, like an email provider, can host and transmit third-party content without subjecting itself to the liability that sometimes attaches to the publisher or speaker of unlawful content. And that's precisely this case, where the only connection to the terrible, horrible, heinous consequences that flowed from the third-party content and conduct, in this case, the only connection to Facebook is publishing those messages in the first place. And to
Counsel,
that point,
are you saying that the algorithms created by Facebook did not allow the connection between traffickers and minors?
if I understand your question, Justice Ryan, there are no allegations in this case regarding connections by algorithms or anything like that. So in terms of the allegations in this case, now again, it wouldn't matter with respect to the legal issue before the court. But I just wanted to be clear about the record and what plaintiffs allege here and what they don't. And to your point,
Counsel, how would you define the word publisher for purposes of this statute? Can you give us a 1 or 2 sentence definition of that?
Sure. I think to treat as, to take the statute in its whole context, to treat as a publisher or a speaker is to hold a provider liable for things that publishers and speakers typically do. Another easy formulation of that is if you can trace the connection back. I think this is what Justice Guzman was saying with the Second Circuit's inextricably intertwined language. The Fifth Circuit has said quintessentially related. I think all of the language in the courts are getting at the same time. The issue is if it's intertwined, if it's not separable from the third party content, there's no way to not to hold a provider liable based on treating that provider as a publisher, where the only connection is the third party content. And that's exactly what we have here. And I think this case, the issue is particularly pronounced because there's no disagreement that Facebook itself bans this content from its platforms. It removes it. It eradicates it. Facebook abhors this content. The issue here is this court enforcing the plain text of Section 230, all of the case law that's interpreting it and ordering plaintiffs' claims dismissed. Thank you, Your Honors.
Any other questions? Thank you, Ms. Ho. That concludes the arguments we have for this morning. This case is submitted, and the clerk will adjourn the court.
Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas now stands adjourned.